The specter of a certain kind of skepticism haunts the philosophy of law. The engagement of early modern philosophy with skepticism traced an arc from the epistemological skepticism from which Descartes recoiled to the more radical semantic skepticism that Kant was concerned to forestall. Where Descartes' inquiry into the conditions of the possibility of empirical knowledge could take for granted the subject's grasp of ideas that at least purported to represent how the objective world really is, Kant dug deeper to investigate what's required to make intelligible the contentfulness of any of our ideas. And the sort of skepticism in the philosophy of law that I'm concerned with here is also a specifically semantic skepticism. Well, there are legitimate epistemological questions about the practices and procedures by which various participants seek to know what the law is. The semantic issues I'm addressing here are a matter rather of the intelligibility of the determinate contentfulness of the concepts that articulate those laws. The reason the rather abstract issue of semantic skepticism about the determinateness of legal concepts matters is that the rational authority of legal judgments and legal argumentation derives from the capacity of laws articulated by those concepts to serve as reasons justifying those judgments. The significance of the semantics of legal concepts lies in the normative pragmatic difference that it makes. The content of concepts affects what one is committed and entitled to by applying those concepts in judgments and argumentation. Some kinds of semantic indeterminateness of legal concepts would undercut the rational credentials of legal arguments and the normative authority of legal judgments. It's essential to the normative bindingness of applications of legal concepts to particular cases that those applications can be rationally licensed by laws articulated by those concepts. And insofar as legal concepts are semantically indeterminate, in a way that would preclude their functioning appropriately in justifications of legal decisions, one would be obliged to adopt a form of legal realism about those decisions that is maybe indistinguishable from legal nihilism. For the idea that there's a difference between exercising normative authority by appeal to law and simply exercising power in its name depends on the possibility of distinguishing applications of the law that are rationally justifiable in virtue of the meanings of the concepts that articulate the law from those that are not. So, one way of approaching the question of what sort of semantic skepticism must be avoided so as not to fall into legal nihilism about the rationality of legal argumentation and judgment concerning the application of legal concepts is to ask, what sort of determinateness of content is required for legal concepts to support assessments of what applications are and what are not rationally justified by principles expressed by the use of those concepts. The sort of indeterminateness of legal concepts that would pose a threat to the rational authority of legal reasoning is indeterminateness concerning which inferences to legal conclusions, that is, conclusions that make essential use of legal concepts, are materially good or bad ones, and which additional considerations would either defeat them or reinstate those inferences. Insofar as it's not settled by the contents of legal concepts, what would count as reasons for and against judgments articulated by the use of those concepts, and what additional premises would infirm or support those inferences, that indeterminateness would rob legal judgments in the vicinity of the sort of normative authority that can only derive from applications of legal concepts being subject to appropriately constrained assessments of the goodness of reasons for or against them. Why might one think that legal concepts and principles are semantically indeterminate in this sense? One line of thought that's been philosophically influential over the last half century or so is Wittgenstein's argument that, as I would put the point, norms explicit in the form of statable rules and principles are intelligible as underwriting determinate assessments of the correctness or incorrectness of various applications and inferences only against a background of implicit practical norms. Here's where the pragmatism comes in our story. Consequences, the rules are not self-applying. They don't explicitly say what follows from them or what's incompatible with them. Consequences can be extracted from them only in the context of practices of distinguishing correct from incorrect inferences from those principles serving as premises. For any particular such inferential connection, of course, there might be another explicit rule that told us it was correct to draw that conclusion from the original principle. But the lesson of Lewis Carroll's fable, Achilles and the Tortoise, is that it doesn't in principle make sense to think of all the inferences as codified in explicit principles. The regress of explicit interpretations must bottom out in something that is not an interpretation. As Wittgenstein says, it can't just be a matter of substituting one formulation of the rule for another. You can't dispense with constellations of practices that implicitly treat some applications of concepts as correct and others as incorrect. Norms explicit in the form of rules or principles necessarily float on a sea of norms that are implicit in practice. We could call this the regress of interpretations point. In the case of legal reasoning, it means at a minimum that statute law can be considered semantically determinate in the sense I'm focusing on, only with the help of a context of case law. Although it helps to be reminded by Wittgenstein of the ubiquity of this semantic phenomenon, legal practitioners, I think, hardly need to be reminded of it in the case of legal concepts. No one with any actual experience with the law thinks you can figure out what it is just by reading the statutes. Too many of the terms occurring there are applied according to standards that can only be gleaned from the case law. And the rest appeal to terms whose home is elsewhere in the law, but whose standards of application also must be understood in connection with the relevant case law. In the Uniform Commercial Code in the US, for instance, some crucial terms, like commercial reasonableness, are left wholly undefined. Some, for instance, unconscionable contractual condition, are undefined but implicitly appeal to the body of contract and common law more generally, while others, e.g., buyer in the ordinary course of business, are explicitly defined, but the definitions evidently have such an open texture that one would be foolish indeed to assume one could settle how they would apply to many possible cases without consulting the case law record of actual applications. The upshot of these considerations is that the place to investigate the nature of the semantic determinateness of legal concepts is common law rather than statute law. For although one's first impression might be that things should be clearer where there are explicitly legislated statutes to appeal to, in fact, understanding the contents of the legal concepts appealed to in those statutes depends on norms that are implicit in the practice of the environment of case law in which they actually function. It's accordingly to that practical context that we must look to assess the nature and extent of the semantic determinateness of legal concepts, as it bears on the understanding of the rational authority of legal reasoning and hence legal judgments. Common law is case law all the way down, so it provides a particularly useful test bench. Now, we could ask, why should the fact that legal norms explicit in the form of rules depend on conceptual norms implicit in practices threaten the determinateness of those norms? Here's a story that depends on two principal arguments concerning the relation between practices of instituting conceptual norms and practices of applying them in judgment and reasoning. According to one model, these are distinct sequential phases in a process that requires both. First, one fixes the contents or meanings of one's concepts. And then, afterwards, one looks to see which applications of them are correct, given those meanings. The early modern tradition was structured around a version of this model. Ideas just came with their contents, and it was up to the minds to apply them to find out what's true. As the heyday of ideas gave way to the heyday of words in philosophy, the first stage could be thought of in terms of associating ideas with words. Inspired by artificial languages, Rudolf Carnap promulgated such a two-phase model. Defining a language is associating meanings with expressions. Then, and only then, the language is available to formulate a theory by finding out which expressions are made true by the world, given their meanings. Quine objects to applying to natural languages this model appropriate to artificial languages. He objects on pragmatist grounds. There's only one thing we do with natural languages, he says: use them paradigmatically to reason and make claims. Doing that is applying meaningful expressions to the non-linguistic world. But it also must be intelligible as instituting the association of meanings with expressions. If we give up what he called the myth of the museum, the idea of a realm of naturally or intrinsically meaningful items, we must conclude that all there is to make our expressions meaningful is the use we make of them in reasoning and judging. In place of Carnap's two-phase model, Quine proposes a unified pragmatist model of language use in which the institution and application of what I've called conceptual norms are aspects of discursive practice rather than phases of it. On his conception, there's no way to assign responsibility for various aspects of our practice to the meanings we deploy rather than the facts we confront, and no principled distinction, accordingly, between change of meaning and change of belief. What Carnap thinks of as language, the realm of meaning, and what he thinks of as theory, the application of meaning in inference and assertion, necessarily develop hand in hand. What's real is just the reasoning and judging that are the use of language, and there's no prospect of somehow factoring out the contributions each aspect makes to that practice. One can't make sense of the notion of instituting conceptual norms apart from the concept of applying them. They're reciprocally dependent conditions. This is the first of the two arguments about the relations between the institution and the application of conceptual norms that I referred to a minute ago. Replacing the two-phase model with the pragmatist holistic two-aspect picture has consequences for how we think of the determinateness of the conceptual norms that are at once both instituted and applied in discursive practice. The second argument accordingly begins where the first leaves off. It raises doubts about the determinateness of conceptual norms that are instituted by any actual course of application of concepts. It argues that the use of concepts must underdetermine their contents. This argument depends on what have come to be known in philosophy as the rule-following considerations, in the wake of what Saul Kripke made of Wittgenstein's treatment in the Philosophical Investigations. As I would boil down this complex constellation of philosophical considerations, the argument that matters in the present context can be thought of as having 5 steps, and I rehearse these on the handout that you should have. The first is the reminder that what the dual aspect picture tells us must be instituted in the course of applying concepts in reasoning and judgment is norms for the assessment of applications as correct or mistaken. The idea of conceptual content is the idea of something that has an essentially normative significance. The contents of the concepts applied must be capable of supporting justifications of some applications and must be the right sort of thing to be appealed to as reasons in rational assessments of the correctness of those applications, according to the norms we can see as articulated by those contents. A central criterion of adequacy of accounts of the relation between the fixing of conceptual contents and the practice of applying those contents in reasoning and judgment is that the contents must be understood as providing norms for rational assessment of the correctness of applications of the concepts whose contents they are. It must be possible to make sense of a thinker as both applying a particular concept and doing so incorrectly, in the sense that in the situation in which the concept is applied, the content of the concept does not provide an adequate reason for applying it. We could call this the normativity of conceptual content point. The second of the 5 steps in the argument is the observation that the normativity of conceptual content point raises what is at least a prima facie problem for the idea that it's the process or practice of applying concepts that determines their contents. The problem is that such an enterprise seems doomed to commit what in reflections on ethical norms is called the naturalistic fallacy. For acknowledgement of the normative significance of conceptual contents means that understanding such contents to be conferred by the process of actually applying concepts requires a transition from is to ought. Somehow, what practitioners actually do, you think of the common law, accepting some arguments and judgments articulated by a given constellation of concepts and rejecting others, must be intelligible as, in the end, settling what practitioners ought to do, which such applications would be correct in the sense of rationally justifiable by appeal to the contents of those concepts, and which not. At this second step, as I'm construing the argument, one simply points to a feature of the challenge faced by the dual aspect approaches. A theory must be offered of how norms can be instituted by practices of actually applying concepts. And at the third step, a skeptical argument is offered that the challenge to accounts of the determination of conceptual content by the actual application of concepts that's raised by acknowledging the essentially normative significance of conceptual contents cannot be met. The argument turns on the observation that any actual course of prior applications of a concept can comprise at most a finite number of occasions on which practitioners actually apply or withhold applications of the concept. Yet those applications are being asked to settle the correctness of a potentially infinite set of further novel applications of the concepts. The trouble is that there will always be many different ways of extending the prior practice to those future potential cases, many different ways of going on in the same way, to use Wittgenstein's phrase. Any finite number of cases are similar to one another in an infinite number of respects, and dissimilar from one another in an infinite number of respects. What is it about the actual cases that should be understood as privileging some of those respects of similarity as those that should be projected to govern assessments of novel cases? Privileging is itself a normative notion. It seems that the finite number of actual applications provides no resources for underwriting this normative discrimination among their actual shared features of some that are uniquely endorsed. We could call this the gerrymandering point. The final 2 steps in the 5-step argument point to fatal flaws afflicting 2 general ways one might seek to respond to the argument that culminates in the gerrymandering point. Each runs afoul of considerations that were already put in place earlier in the argument. The first considers the possibility of privileging some projectable respects of similarity of actual applications, some ways of going on in the same way, by explicitly saying which are to be projected. The trouble with this line of thought is that in the context of worries about the intelligibility of actual applications instituting determinate conceptual norms, it collides with the regress of interpretations point. For that point was that what one explicitly says, the rules or principles one endorses, can be understood as laying down determinate normative constraints only in virtue of a background of implicit practical abilities to distinguish correct from incorrect applications of the concepts used to state the rule or principle. And what's at issue is just how that latter can be understood to be working. So any response along those lines would be circular. The final step in the argument addresses a different approach. Since appeal to actual applications is too weak, it fails to satisfy the criteria of adequacy of determining norms, and appeal to rules is too strong, this strategy looks to something intermediate in strength, namely dispositions to apply the concepts in question. On the one hand, the dispositions reach well beyond actual past applications, governing merely virtual possible future applications as well, On the other hand, they too, the dispositions, are implicit in practical know-how, not appealing to explicit knowing that of the kind that's expressed in conceptually articulated, explicit principles and rules. The trouble with such an otherwise promising dispositional approach is that it fails to satisfy the normativity of content criterion of adequacy. We would need a dispositional understanding that supports assessments of correctness and makes intelligible the notion of mistake. But dispositions, like actual applications, just are what they are. They don't err. No one can fail to respond as they're disposed to respond. On a dispositional account, as Wittgenstein says, whatever seems to me to be right is right. And that just means that the normative notion of right goes missing. In some regularist positions, which invoke matter-of-factual regularities or dispositions, fail to institute genuinely constraining norms. And regulist positions, which invoke explicit rules or principles, something which can be said as opposed to just done, end up being circular through failure to appreciate the regress of interpretation's point about how normative knowing that depends on normative knowing how. So I began by characterizing a theoretical worry in the philosophy of law about the rational justifiability of legal reasoning and judgment, a worry that's rooted in a distinctive kind of semantic skepticism. And I further rehearsed a line of argument in the philosophy of language supporting that kind of semantic skepticism. That argument starts from an appreciation of the normative significance of the contents that any concept must have for the justification and assessment of the correct use of that concept. That argument is not restricted to legal or more generally normative concepts, though of course it applies to them too. There's another argument, though, that's specifically skeptical about the contents of normative concepts, and so of legal ones. Though it's abroad in many versions, Gilbert Harman's development of it is particularly clear and forceful. It concerns the relations between norms and normative attitudes. To avoid possible confusion, I'll talk about normative statuses, such as being responsible or committed, having authority, or being entitled, on the one hand, and normative attitudes of practically taking or treating someone, whether implicitly or explicitly, as having such a status, being committed or entitled. Put in these terms, Harman claims that there's a crucial distinction between the way specifically normative concepts are related to the normative attitudes one expresses in applying those concepts, and the way ordinary empirical concepts are related to the attitudes one expresses in applying them. In the latter case, for concepts such as mass or cat, the best explanation for our attitudes towards mass and cats is that there really are such things as mass and cats. In the case of normative attitudes, though, Harman claims the best explanation for our attitudes, for taking or treating people as committed or entitled, authoritative or responsible, need appeal only to other normative attitudes. We need not postulate the existence of normative statuses of commitment and entitlement that are being acknowledged in adopting our normative attitudes. All we need to countenance is normative attitudes, not norms or normative statuses. For Harman, it's normative attitudes all the way down. We just make assessments the way we've been taught to. Attitudes get reproduced in attitudes. In the rest of my talk, I present a way of thinking about the determinate contentfulness of concepts that's a constructive alternative both to this Harmanian skepticism about the applicability of normative concepts in particular, rooted in a reductionism that sees only normative attitudes and no real normative statuses for them to be attitudes towards, and to the skeptical attitude about the determinate contentfulness of concepts generally, not just normative ones, that's argued for on the basis of difficulties of understanding the normative practical significance of applying those concepts. The alternative model that I will elaborate is due to Hegel, but you don't need to know anything about it. Hegel. Hegel introduces a model that's at once a non-reductive way of bridging the is-ought gap that the rhetoric of the naturalistic fallacy threatens to open up, and at the same time a response to Harmanian skepticism about the reality of norms. It's a structure whereby genuine normative statuses are instituted by a suitable constellation of actual normative attitudes. This is the structure of reciprocal authority and responsibility that Hegel talks about under the rubric of mutual recognition. The normative status with which he introduces this idea is that of being a self, in the normative sense of being a subject of normative statuses, that is, one who can undertake responsibilities and exercise authority. The fundamental normative attitude he calls recognition, Anerkennung. Recognizing someone is taking or treating them in practice as a normative subject, that is, as able to undertake responsibilities and exercise authority, paradigmatically by making judgments and acting intentionally. And his basic idea is that normative statuses are social statuses. This is Hegel's version of the Enlightenment thought that normative statuses such as responsibility and authority are products of human activity. The world didn't come with such normative statuses in it. It required us to practically take or treat each other as responsible and authoritative, for us to be responsible and authoritative. The way Hegel develops his social approach to normativity is this: it's necessary and sufficient to be a normative subject that one is recognized as such by those one recognizes as such. When recognitive attitudes are in this way reciprocal, gegenseitig, they institute a genuine normative status, normative selfhood or subjecthood. To be a self in this normative sense is to be taken to be one by those one takes to be selves. Recognizing others is attributing to them a certain kind of authority, the authority constitutively to recognize others. If they exercise that authority by recognizing the original recognizer, that recognizer is thereby socially constituted as a normative self. Being able to be responsible, a normative status, depends on others holding one responsible, a normative attitude. Whose attitudes matter for someone's status depends on who that person recognizes. As this summary suggests, reciprocal recognition as the condition of normative attitudes instituting normative statuses invokes quite a distinctive constellation of authority and responsibility. One way to see that is to think about a less global normative status, say being a good chess player. The reciprocal recognition model counsels us to look at the status instituted when someone is recognized as a good chess player by those he recognizes as good chess players. The candidate has full authority over his own attitudes, hence over who he recognizes as good chess players. But in adopting such an attitude, in recognizing some actual collection of chess players as good ones, in the sense in which he aspires to be a good one, the candidate cedes to them a corresponding authority, the authority to constitute him as a good chess player in that sense by recognizing him or not. The candidate can make this recognition easy to earn. If he recognizes just any wood pusher who can play a legal game as a good chess player, then it won't be hard to be recognized in turn as meeting that standard. But then he's only constituted as having the normative status of a good chess player in this very weak sense. If instead he recognizes only formidable club players, or only masters or grandmasters, it'll be correspondingly difficult to achieve their reciprocal recognition. On the other hand, if he succeeds in doing so, he's constituted as a good chess player in a much more demanding sense of good, and achieves a much more valuable normative status. One cannot constitute oneself as a good chess player without the cooperation of those one recognizes as having that status. I think it's useful to think in this connection of the status of being a good writer or a good philosopher. On this account, it's up to each agent whether to undertake a commitment or claim an entitlement. But what the status that's instituted determinately is up to those one has made oneself responsible to by recognizing them in this regard. The determinate content of the commitment undertaken is not in the same sense up to the one who undertakes it. For authority to determine its content has been ceded to those the agent has authorized, that is, has recognized as entitled to hold her responsible. Thus, it is up to me whether, for a consideration, I agree to return the property to its previous owner. It's not then up to me whether what I've done counts as complete performance of my duties under the contract. Although normative statuses of this kind are instituted by reciprocal recognitive attitudes, the social division of labor between the mutually recognized and recognizing parties ensures that it is not the case that whatever seems right is right. The status is not determined by the attitudes of any one party. In a minute, I'll try to say how this fact bears on our understanding of the determinate contentfulness of the normative statuses that are socially instituted by mutual recognition. Now, the recognitive model is a broadly naturalistic one, at least in the sense that the advent of this kind of norms in a natural world is not mysterious. This account of what normative statuses are exhibits them as products of matter-of-factual normative attitudes as long as they have the right social structure. In one sense, such an understanding of normative statuses is congenial to the Harman line of thought, for in one sense, it is attitudes all the way down. Understanding normative attitudes is sufficient to understand normative statuses. But on the recognitive account, we do not need to deny that in addition to normative attitudes, there are normative statuses that they institute. On this account, there is something normative attitudes are attitudes towards genuine norms. Now, Hegel also has a constructive response to Kripkensteinian worries about the intelligibility of the idea that determinate conceptual norms can be determined by applications of concepts. I introduced this issue as the product of two ideas: the normative character of conceptual content and the transition from a two-stage story, according to which conceptual norms are first instituted and then in a separate subsequent stage applied, the transition from that to a two-aspect story, according to which the process or the practice of using concepts must be intelligible as at once instituting and applying conceptual norms. The difficulty Kripke's Wittgenstein raises is that it seems that the actual use of concepts radically underdetermines the norms that articulate their content. The key to Hegel's constructive response to the challenge of understanding how and in what sense the practice of actually applying concepts can at the same time be the practice that institutes determinate norms for doing so. Remember, I suggested we look over our shoulders at common law in thinking about this, is that his account is not only social, but historical. Hegel's fundamental reciprocal recognition model of the constellation of authority and responsibility by which normative attitudes institute genuine normative statuses has a diachronic species in which the recognitive community that institutes conceptual norms takes the distinctive form of a tradition. In addition to the social reciprocal recognition account, Hegel's account of determinateness crucially depends on that historical dimension of concepts use. It's this fact that makes his account of concept use generally of particular significance when applied to the understanding of the process of determination of legal concepts, to which I now return. Ronald Dworkin famously suggested modeling the development of laws and the legal concepts that articulate them to the writing of a chain novel. Each judge inherits a more or less settled textual corpus comprising earlier applications and interpretations of some set of concepts and principles, and is obliged to extend it. Here's how Dworkin puts what he sees as common to the task of the judge and the author of the chain novel in medias res. He says, quote, "Your assignment is to make of the text the best it can be, and you will therefore choose the interpretation you believe makes the work more significant or otherwise better." This is from Law's Empire. End of the quote. It's clear that this model is getting at something important about case law and about common law, which, as I say, can be thought of as case law all the way down. In the almost 40 years since its original promulgation, I think we've also come to see some of the drawbacks of this Dworkin view. For one thing, it's not clear how helpful it is to understand the fixed end of the analogy with the development of law in terms of a chain novel, a work of fiction. The dimensions along which it's appropriate to assess literary works and legal traditions are just too disparate and divergent. There are too many senses of better, and we don't get enough help in filling them in. My suggestion is that the diachronic historical species of Hegel's generic reciprocal recognition model of the institution of normative statuses by normative attitudes specifies a substantive structure of authority and responsibility that lets us fill in the normative fine structure gestured at but not supplied by Dworkin's chain novel metaphor. Hegel's account, as I understand it, is aimed at a discursive practice and the development of determinate conceptual contents generally. It becomes particularly pointed and significant when applied to the explicit, self-conscious, institutionalized context in which legal concepts develop. We might start with the observation that we want to say both that judges are responsible for the law and that judges are responsible to the law. Hegel's account of the reciprocal recognitive structure of the process by which legal concepts and principles are determined provides a way of understanding these symmetric claims according to which we can be entitled to both of them. The sense in which judges are responsible for case and so common law is what lies behind calling it judge-made law. There's nothing to such law that isn't the cumulative result of judicial decisions to apply or not to apply the concepts, say strict liability, in particular cases. In selecting the prior cases she treats as precedential and the features of the fact she takes as salient in making the decision and providing a rationale for it, the judge both further determines, in the sense of sharpening, the content of the legal concepts involved, and provides precedents and rationales to which future judges are at least potentially responsible. In this way, the deciding judge exercises authority over both the content of the legal concepts being applied and therefore over the decisions of future judges, in the sense of what norms their decision should be assessed according to for their correctness. That description shows that there's also a sense in which any deciding judge is responsible to the content of the concept whose applicability is being assessed, which she inherits from the tradition. For she's bound by the authority of the prior judges, whose decisions are available to provide precedents, considerations, and rationales. For the justification of a judge's decision can appeal only to the authority of prior decisions, and so to the conceptual content those decisions have conferred on or discovered in the legal term in question. The current judge is responsible to the conceptual content that articulates a legal norm by being responsible to the attitudes of previous judges as reflected in their actual decisions. Stare decisis, the authority of precedent, is a matter of how actual normative attitudes determine subsequent normative statuses. In offering a rationale, a justification for a decision, the judge presents what is in effect a rational reconstruction of the tradition that makes it visible as authoritative insofar as presented, the tradition at once determines the conceptual content one is adjudicating the application of and reveals what that content is, and so how the current question of applicability ought to be decided. It's a reconstruction because some prior decisions are treated practically as irrelevant, non-precedential, or incorrect, and are effectively extruded from the tradition as reconstructed. The result is a rational reconstruction insofar as there's a standing obligation that the prior applications that are embraced by a rationale as precedential and salient must fit together with the new commitment that is the decision being made. The rationale is an account delineating the boundaries of the authority of the conceptual content associated with a legal term, determined by the attitudes of the prior judge's precedential decisions and rationales to which the current judge is responsible, in the sense that that content sets the standards for future normative assessments of the correctness of the current judge's decision. This sort of practice or process of sequential rational integration of new commitments into a constellation of prior commitments institutes normative statuses of authority and responsibility according to the model of reciprocal recognition. Each deciding judge both recognizes the authority of and is responsible to past decisions, and so the contents they both acknowledge and help to institute, over the assessment of the correctness of the decision being made. The deciding judge also exercises authority over future judges who are constrained by that judge's decision insofar as they are precedential. But the currently deciding judge is also responsible to and held responsible by future judges who can, by their practical attitudes, either take the current decision and rationale to be correct and precedential or not. For the current judge actually to exercise the authority the decision implicitly petitions for recognition of, it must be recognized by future judges who take the current judge to have appropriately acknowledged the authority of past judges. And if that precedential authority is recognized by the later judges, then it's real. A normative status has been instituted by those attitudes, according to the model of reciprocal recognition. Both in acknowledging and in claiming the authority of precedent, the judge is implicitly acknowledging the authority also of future judges who administer that authority. For they assess whether the new commitment has been appropriately integrated with prior commitments and decide on that basis whether to acknowledge it as authoritative, as normatively constraining future commitments in that they must be integrated with it. So each judge is recognized implicitly as authoritative both by prior judges, the ones whose decisions are being assessed as precedential or not, and explicitly by future judges, the ones who assess the current decision as authoritative, that is, as precedential or not. And each judge recognizes the authority both of prior judges, to whose precedential decisions the current judge is responsible, and of future judges, on whose assessments of the extent to which the present judge has fulfilled his responsibility to the decisions of prior judges, the present judge's authority depends. Because the future stands to the present as the present does to the past, and there is no final authority, every judge is symmetrically recognized and recognizing. One of Hegel's key ideas, as I read him, is that in order to understand how the historical process of applying determinately contentful concepts to undertake discursive commitments can also be the process of determining the contents of those commitments, we need a new notion of determinateness. What we might call Fregean determinateness is a matter of sharp, complete boundaries. For the logician Frege, each concept must be determinate in the sense it must be semantically settled in advance for every concept, for every object, definitively and in advance of applying the concept epistemically, whether the object does or does not fall under the concept. What corresponds to Fregean determinateness for conceptual contents is a matter of the inferential relations, the role that it plays as a premise or a conclusion. That's what has to have sharp boundaries, what follows from or is a reason against the claim. Hegel associates the demand for conceptual contents that are definite in that sense with Kant. It's the central element of the meta-conceptual framework Hegel calls Verstand, understanding. And he proposes to replace this static way of thinking about the determinateness of relations of implication that articulate conceptual contents with a dynamic account of the process of determining those contents. And it's that pragmatist notion he calls Vernunft, reason. Roughly, he thinks the old static framework is what you get if you assume that those applying the concepts always already have available the contents that would result from completing the process of determining those contents by sequential rational integration. He's very much aware of the openness of the use of expressions that is the practice at once of applying concepts in judgment and determining the content of those concepts, of the concepts those locutions express. Hegel wants us to step back and ask a basic question. What kind of fact is it that prior uses constrain but don't settle, in the Kant-Frege sense, how it would be correct to go on? And his answer is that what is correct is a matter of normative status, of what one is and isn't committed to or entitled to, responsible for, and what would authorize such commitments. On his account, that kind of fact is a social recognitive fact, one further that's instituted by processes with that distinctive historical version of the structure of reciprocal recognition. And he uses that structure to fill in the details of a new notion of determinateness. What Hegel adds is a retrospective notion of rationally reconstructing the process that has led to the commitments currently being integrated, not just the new one, but all the prior ones that are taken as precedential for it as well. This is a kind of genealogical justification or vindication of those commitments, showing why previous judgments were correct in the light of still earlier ones, and in a different sense, also in the light of subsequent ones. Hegel calls this process Erinnerung, recollection. A good example of it is the sort of Whiggish triumphalist rationally reconstructed history of their disciplines that you'd find in old-fashioned science and mathematics textbooks. Such a story supplements an account of what we now know with an account of how we found it out. Hegel thinks that our activity of telling, rationalizing stories like this is the form of what he calls reason's march through history. It's the way we retrospectively make our applications of concepts have been rational in the sense of genuinely responsive to discursive norms by, after the fact, finding a way concretely to take them to be rational in that sense. For in rationally reconstructing the tradition, concept users retrospectively discern conceptual norms that are determinately contentful in the Kantian Verstand sense as having been in play all along. But this new notion of determinateness that Hegel proposes is an essentially temporally perspectival one. Looked at retrospectively, the process of determining conceptual contents by applying them appears as a theoretical epistemic sense. One is determining the conceptual contents in the sense of finding out which are the right ones, which norms really govern the process. That is, finding out what really follows from what and what's really incompatible with what. A recollective reconstruction of the tradition culminating in the current set of conceptual commitments and contents shows from the point of view of that set of commitments and concepts, taken as correct, how we gradually, step by step, came to acknowledge in our attitudes the norms that all along, according to the story, implicitly governed our practices. Looked at prospectively, though, the process of determining conceptual contents by applying them appears as a practical, constructive, semantic task. By applying concepts to novel particulars, one is determining the conceptual contents in the sense of making it the case that some applications are correct by taking it to be the case that they are. One is drawing new, more definite boundaries where many possibilities existed before. That's the judges making the law. By investing one's authority in an application as being correct, one authorizes those who apply the concept to future cases to do so also. If they in turn recognize one in this specific respect by acknowledging that authority, then a more determinate norm has been socially instituted. From this point of view, conceptual norms are never fully determinate in the Kant-Frege Verstand sense, since there's always room for further determination. The conceptual norms are not completely indeterminate either, since a lot of actual applications have been endorsed as correct by potentially precedent-setting judgments. All the determinateness the content has is the product of that activity. So, are the concepts determinate in the Kant-Frege sense, as the retrospective perspective has it, or indeterminate, as the prospective perspective has it? Hegel thinks if all you've got is that static Verstand framework, you could say both, you could say neither. There's no good answer. Those two answers just don't make any sense in the Verstand framework. What we should say is that concepts have contents that are both determinate and further determinable in the sense provided by the dynamic, pragmatic, temporally perspectival framework of Vernunft. Do we make our concepts or do we find them? Are we authoritative over them or responsible to them? Here, Hegel can answer both, for both aspects are equally essential to the functioning of concepts in the ever-evolving constellation of them. Authority and responsibility are coordinate and reciprocal according to the mutual recognition model of normativity. And when that structure of reciprocal recognitive attitudes takes the special form of a historical developmental process, the contents of those attitudes and statuses they institute can be considered from both the prospective and retrospective temporal perspectives. Each judge's acknowledgement of the authority of her predecessors consists in justifying her decision by a rationale that retrospectively discerns an expressively progressive trajectory through past precedential decisions. Hegel thinks of this as giving contingency the normative form of necessity. Telling the retrospective rationalizing story that discerns a norm is a way in which traditions can be lived forwards but understood backwards. The posture of discursive traditions going forward is shaped by backward-facing recollective understandings. The intricate interplay of assertions of authority and acknowledgments of responsibility, displaying the structure of reciprocal recognition, is the process by which contingent normative attitudes, decisions, institute genuinely determinately contentful norms. The shape of the debate within jurisprudential theory about how to understand the determinateness of legal norms, and hence the rational authority of legal reasoning, offers a striking expression of the unhelpfulness of thinking about conceptual contents according to the static Verstand model. According to one view, the law is what some judge takes it to be. A statement of what is legal, a normative status, is a matter of factual prediction about what a judge would decide, the judge's normative attitude. Extreme forms of that view, in addition, can insist that what the judge says is typically determined by non-legal reasons or causes. What the judge had for breakfast, as the slogan has it. On the other side, more in keeping with the phenomenology of responsible jurisprudence, is a view according to which the judge's job is not to make the law, but to find out what it already is. But on the Hegelian view, both of these are literally one-sided misconceptions. The former sees only the judge's authority, but not her responsibility. And the latter sees only her responsibility, but not her authority. What's needed is a structural account that does justice to both, to their essential interrelations with one another, and to the way the processes of which both are aspects determines determinate conceptual contents. Hegel's new notion of determinateness, made possible by the intricate diachronic reciprocal recognition model of the relations of authority and responsibility in an evolving tradition of legal construction, is offered as a response to just these criteria of adequacy.